comment on this case, which is one of the most exciting cases I think is going on at the WTO level, which is the dispute brought by the United States against China on the certain measures affecting the protection and enforcement of intellectual property rights. You may know that this is a dispute with a lot of background. There is a lot of history about this. In fact, this issue has been on the agenda of the USTR for several years, even prior to the accession of China to the WTO, even prior to the creation of the WTO itself. So when we're talking about this case, we're talking about a lot. The concerns of the US have been on the table at the time. They have shifted in the course of the years. In the beginning, there were some concerns about legislation and enforcement. Now we're more focused on enforcement. Actually, if you look at the latest reports of the USTR on the special 301 instrument, you will see that, I mean, when they refer to legislation, they talk just a very little about it. At the same time, as a reaction to these kind of concerns, China has made several attempts to try to address the concerns of the EC, the United States, and other trading partners. In the context of its accession to the WTO, China made substantial change to its legislation. Across the time, China has also made changes to its enforcement policies. As a matter of fact, in a few days prior to the initiation of the dispute, China issued a couple of regulations. One was a decision or a ruling of the Supreme Court with respect to one of the measures that is at stake in this case, a decision, a judicial interpretation lowering the thresholds with respect to the prosecution of criminal actions. However, China's efforts have not been sufficient to convince the United States, and the United States requested consultations in the course of or pursuant to a DSU, to this settlement understanding, in April this year. The United States requested consultations pursuant to Article 64 of the TRIPS agreement in connection with Article 22, which allowed for open consultations. There were some WTO members who joined this process: Canada, the European Union, Japan, Mexico. Consultations took place in June. Consultations didn't resolve the matter. So the United States decided to request the establishment of the panel, which is one step further, going to the adjudication process. This request was made in August, and finally the panel has been established on the 25th of September this year. Some countries have requested to participate in this proceeding as third parties. So far we have the European communities, Japan, Mexico, Chinese Taipei, and Argentina. I guess the deadline was last Friday, and now at this stage the panel has been established. The next step is the constitution of the panel. The parties can agree to the appointment of panelists, but if they don't reach any particular agreement, finally they can request the Director General to appoint the panelists. Once the panelists are appointed, and once the schedule of the proceedings and the working procedures are set out, then nothing can prevent the panel from issuing a final resolution to this dispute. Well, there's one exception: the agreement of the parties and a request by the US to suspend proceedings pursuant to a DSU. But otherwise, we're going to have a ruling, a substantive ruling on this issue. And what is going to be this ruling all about? It's going to be about three areas of concern that have been raised by the United States in its request for the establishment of the panel. The first one refers to the issue of the thresholds for criminal procedures and penalties, which is a direct challenge to China's criminal law and judicial interpretations construing certain provisions of the criminal code. The second refers to the issue of whether Chinese authorities have the authority, let's put it this way, to destroy goods when these goods are infringing IP law, and whether, you know, what is currently happening in China, which is that China is removing certain aspects or the infringing aspects of goods subject to this regulation, whether the removal of these infringing aspects is sufficient to permit the release of these goods into channels of commerce. And finally, the third claim, the third measure at issue is the denial of copyrights with respect to works for which the publication and the distribution hasn't been authorized. So these are the three issues at stake, and now we're going to talk about each of them. What happened with the issue of the thresholds for criminal procedures and penalties? Under China's criminal code, trademark and copyright violations are subject to imprisonment and are also subject to certain fines. However, there is a specific, there is a very interesting qualifier, is that not all type of infringements are subject to these penalties. And this qualifier is this kind of criteria. For example, with respect to infringements related to trademarks, to the selling of goods on counterfeited goods, to the selling of counterfeited goods, penalties arise under circumstances of a serious character, of a special or circumstances especially serious. With respect, for example, to copyright violations, criminal actions can be pursued if the amount of illegal gains is relatively large or huge. Now, in terms of WTO jurisprudence, you may wonder, what is the problem about this? I mean, there is a classical distinction between mandatory and discretionary legislation, and to the extent that, let's say, a judge interprets this kind of criteria in such a manner that the country, at the end of the day, honors its commitments with the WTO, that's fine. That's something already well established. The situation is here a little bit complicated, though, because the Supreme Court of China has already defined this criteria, and has defined this criteria imposing certain quantitative benchmarks. I can give you an example. For example, with respect to the issue of the sales of counterfeited trademark goods, there is one criteria. There's one criterion which applies, which is that the amounts of sales have to be relatively large or huge. The Supreme Court of China has construed the criterion of large amount of sales as equivalent to sales of no less than 50,000 RMBs. In the case of amounts of sales which are huge, the criterion is no less than 250,000 RMBs. So, what is the consequence of the imposition, or what is the consequence of these benchmarks? Well, basically that anything that falls below the benchmark is not subject to these procedures and is not subject to penalties. And this is the statement, this is the proposition that the United States is putting forward. The United States considers that not all cases of infringement are subject to criminal procedures and penalties, or are sanctioned with penalties that provide a sufficient deterrent. Now, what is the problem with this? The United States invokes violations of Articles 41, 1, and 61 of the TRIPS agreement. These general provisions provide for the availability of criminal procedures and penalties in order to counter in an effective manner any infringement of intellectual property rights. And the remedies accruing from these procedures have to provide sufficient deterrent to further infringements. This is the general one, 41.1. 61 refers to the specific situation of willful trademark counterfeiting or copyright piracy. However, look at this here. It says willful trademark counterfeiting or copyright piracy on a commercial scale. That is something that we don't find in the general provision under 41.1. And besides, when we talk about the remedies that have to result from these proceedings, in the general provision we just have a reference to deterrent to further infringements, where here The definition of the term refers to the term consistently with the level of penalties applied for crimes of a corresponding gravity. So there are some questions that arise from here. One of the questions is, what is the meaning, for example, of commercial scale in this respect? Could commercial scale be construed as allowing members, for example, to determine what is under commercial scale, what is not under commercial scale? Is it possible to refer to some parameters, to some criteria? Is it possible to refer to some sort of threshold? Who knows? Only the panels will resolve this issue at some point. What about the issue of the term have to be somehow bearing a correlation? Oops, oh, it's very short. Okay, somehow bearing a correlation with penalties applied from crimes of a corresponding gravity. Who determines whether certain crimes are of a corresponding gravity? Criminal law is something that in a way reflects the highest values of societies, and perhaps, what is a crime in one country may vary in another jurisdiction. I just leave it there because I think I have to rush in. Now let me refer to the second issue. The second issue is the question of whether customs authorities in China can remove the infringing aspects of a particular good and can permit the release of these goods into channels of commerce. Let me perhaps tell you a little bit what happens in reality. When customs in China find that a good is infringing copyrights or is infringing trademarks, it immediately gives notice to the right holder. Now, the right holder has the option of purchasing this good, providing a certain compensation. If the right holder doesn't exert this option, under Chinese law, custom may give this good to public welfare undertakings. If that situation doesn't happen, then Chinese customs can attempt to remove the infringing aspects of the good, and finally can auction these goods or can, through another means, put them into channels of commerce. And only in case the infringing aspects of a goods cannot be removed is when Chinese authorities destroy the goods. Well, now the US is challenging that this is inconsistent with Articles 46 and 59 of the TRIPS agreement. Why so? 46 has a special provision which says that in regard to counterfeit trademark goods, the simple removal of the trademark unlawfully affixed shall not be sufficient to permit release of the goods into the channels of commerce. It appears then that in the view of the United States, there is something else which is necessary in order to permit the release of goods into the channels of commerce. Now, if you look at the request for the establishment of the panel, at least personally I haven't found that something else that is necessary in this respect. On the other hand, it looks like the US insinuating that goods have to be destroyed anyways. But this leads us to the second challenge of the US with respect to this measure. And the second challenge is to the fact that indeed the authorities in China don't have this authority to destroy goods because the US alleges, and this is also something that is reflected in Chinese legislation, let's say if the authorities can remove the infringing aspects of the goods, then they are under the obligation to place these goods into channels of commerce. And then the US is claiming this is contrary to Article 59 of the TRIPS agreement, because under Article 59, competent authorities shall have this authority, this prerogative, under any circumstances. So this is as far as the second claim is concerned. And finally, this is the third claim with respect to the denial of copyrights because the publication or distribution of the goods to which they relate hasn't been authorized. Under Article 4 of China's copyright law, if a good hasn't been authorized for publication or distribution, then it's not protected under copyright law. Now, the U.S. is claiming that this is inconsistent with Article 9.1 of the TRIPS agreement in relation to the Berne Convention. Indeed, this authorization requirement constitutes a formality, in order for a right holder to avail itself of copyright law. And besides, this authorization, this requirement to get an authorization for distribution and circulation and publication also undermines the right of performers and of phonogram producers with respect to the works for which publication or distribution has not been authorized. The authorization procedure also, apparently also makes certain distinctions with respect to domestic authors and foreign authors. It appears that in the case of domestic authors, the procedures are more expedited, the procedures are less burdensome, the procedures are quicker. Whereas in the case of foreign authors, the procedures are the contrary and rather complex. Therefore, the U.S. is raising a claim under Article 3.1 on national treatment. Finally, given the fact that while authorization is pending, a copyright holder cannot prevent infringement of his copyrights, the U.S. is also claiming that no criminal procedures and penalties are available in order to provide a remedy to these infringements. Therefore, we go back to Article 41.1 and 61 of the TRIPS agreement. So, this is in a nutshell what is this case all about. Just, if you allow me, just an additional minute perhaps to refer to the implication that I can see from this dispute. I have found at least three general implications. The first of them is with respect to interpretation of the TRIPS agreement. There are several provisions of the TRIPS agreement that have never been discussed in the context of WTO jurisprudence. There are several concepts that, in a way, may require the examination of certain aspects related to the specific situation of the country, of the importing country, or the country which is at issue. I wonder whether a WTO panel may be willing to take this option. WTO panels usually rely on Articles 31 and 32 of the Vienna Convention on the Law of Treaties, and these tools provided in these provisions are tools which are completely isolated from what is happening in reality. However, there are a couple of instances in WTO dispute settlement where the appellate body has relied on certain factual circumstances in order to provide meaning to the provisions of the treaty. One was in the U.S. shrimp case, where the appellate body relied on its notion of the evolutionary interpretation of a treaty in order to assert some of the provisions that are issued, precisely Article 20 of the GATT. The second was a dispute on chicken cats, where the appellate body, in order to give meaning to the content of an easy concession, relied on what it called the factual context, which is a category not contained in Articles 31 and 32 of the Vienna Convention. So let's see how the panel and the appellate body proceed in this particular instance. And this is something related, but a bit different though. While in theory, panels and the appellate body have to assess the case on the merits. In practice, experience indicates that in certain instances, panels and appellate body have been more differential to certain domestic policies. And they have been more differential to certain domestic policies that are attached to certain values or to public order in certain way. In the Korea beef case, for example, when the appellate body had to assess whether a measure that was otherwise WTO inconsistent was necessary to achieve certain objectives, it made a statement to the effect that the higher the objective of the society is, the more likely the measure is going to be necessary to achieve that objective. So the only point that I want to make is that the appellate body in a situation involving issues of public order, at least in practice indicate that it has been more differential. The gambling case is another example where the U.S. raised a defense based on public morals and public order. The panel rejected the U.S. defense. The appellate body reversed what the panel said, and the appellate body didn't dispute the characterization that the U.S. itself had given to its law as a measure intended to pursue to protect public morals. Although in the end, it rejected the U.S. defense on other grounds. Finally, with this I finish. Certain implications on enforcement policies for members. Let's say if there is an adverse ruling against China on this, it's likely that China, in order to put this measure into conformity, will have to modify some portions of its legislation, which are here at issue. But at the same time, it may have certain implication on the cost of enforcement. Just to finish, I wonder whether, let's say, a reallocation in the cost of enforcement in this particular respect may raise questions as to whether this is consistent with the last sentence of Article 41.5 of the TRIPS agreement. Thank you for your attention.